Hello and welcome to brandthellc.com. My name is Amina Jones. I am the principal attorney and founding member at the law office of Amina P. Jones, PLLC, or as you may know it as Brand the LLC. So let's get down to it. Trademarks. Now, you're probably here because someone is trying to steal your brand, meaning use your business name, your logo, your colors, or your overall brand image, and you want to know how to protect it. Or you've probably seen one of my posts on my Instagram page, or maybe on Facebook. I'm on Instagram at My Lawyer Amina, or you probably know better, which in that case, good for you. When someone files their trademark, they're filing it with the United States Patent and Trademark Office, or at least they should be, because each state has their own trademark registry. However, what I'd like to compare it to is like clicking each email one by one to mark it as read versus clicking read all to mark all of your emails as read all. Think of every individual state as an email. And of course, if you go to each state registry to register your trademark with them, it's like clicking each email one by one. However, if you decided that you wanted to go with the USPTO, which you should, it's like clicking the read all button to make sure that every single state has your trademark registered. Now, there is an exception. If their trademark is already registered in that particular state, it cannot trump or overcome the trademark in that particular state, which is why the key is to make sure that you register your trademark as early as possible, because you don't want someone in a state, in one of the states, in order to register a part of your mark or the trademark that you're using, and then you can't use the trademark in their state, right? So when we're talking about trademarks, we're discussing the United States Patent and Trademark Office and not any statewide trademark database. It's more affordable, it's more efficient, and it is the smarter thing to do. So let's talk about the trademark process. You can trademark anything that distinguishes your business from another business in the market, meaning that if you have a business name or a business logo or business colors, anything related to your business where you're actively in the market and in business, you can trademark. Now, there is an exception to where you can trademark something that you aren't currently using, which we'll get into. However, the idea is that you have to either be using it or have the intention to use it. That is what you can trademark. Now, before you file for your application, there are a few steps that you need to take in order to make sure that your trademark application is going to be successful, or at least ensure that you've done everything possible to increase those chances of success when filing your trademark application. The first step is that you want to make sure that whatever you're looking to trademark is actually eligible for registration. There are a few different levels that attorneys and the USPTO use to make sure and to do an initial assessment to make sure that the trademark they're looking to register is actually eligible. Meaning that, is it unique enough that someone else in your industry wouldn't need to use those terms or any part of your brand image in order to market their goods and or services? So there's a scale that the USPTO uses and that attorneys use to determine whether your trademark has the type of strength and the viability in order to be registered in the first place. And that scale goes from generic to descriptive to suggestive, and then lastly, fanciful or arbitrary. Now, generic means that you can't have a term that someone else in your industry would need to use in order to promote their goods and or services. So for instance, if you're selling apples, you can't name your company Apple or the Apple company. It's too generic, and of course, any of your competitors that are also selling apples need to use the term apples in order to promote their goods and or services, so that's never eligible for registration. The next step is descriptive. Does your trademark or your brand image describe your goods and or services? So this would be, for instance, if you're selling pizza and the name of your company is called Cheesy Slices, another competitor also would probably use the term Cheesy Slices. At least if they have a really good marketer, they would of course use the term Cheesy Slices. Now that is descriptive, and it doesn't completely bar your chances of getting registration with the United States Patent and Trademark Office. However, it won't go on the principal registry. chances are. If you're not completely denied your registration, it'll go on the supplemental registry. And there are a few differences. You still get protection. However, when it goes on the principal registry, you have the opportunity to make your trademark incontestable, meaning that no one else can challenge it unless it's based completely upon fraud. And there are a few other exceptions, but I won't bore you. That's our job to know the differences. I just want to make sure that you have a broad understanding as to what's required so that when you file your trademark application with us, you know exactly what to expect. The next level up is suggestive. So this is actually a sweet spot for marketers and the trademark because it does suggest what your goods and or services is, but it isn't something that your other competitors would need to use in order to promote their goods and or services. So a perfect example would be Wet Ones. That actually did go to litigation with the Trademark Trials and Appeals Board, the TTAB, which we'll talk about in a few. However, the litigation based on Wet Ones was that it was more descriptive, which, I mean, it does sound like it. However, the attorneys for Wet Ones argued that it was more suggestive. And the Trademark Trials and Appeals Board agreed with them, and Wet Ones is on the principal registry as a suggestive mark. So does it suggest what it is that you do, right? So Wet Ones for wet wipes, that is suggestive. And then the highest and the strongest level of trademark eligibility would be fanciful or arbitrary. Fanciful simply means a made-up word. So words such as Google or Exxon or Kodak, these are made-up words. And then arbitrary means a traditional word that's used in a non-traditional context, such as Apple to sell computers, phones, and other technology. Obviously, they don't sell any apples. So that is the strongest level of trademark protection. So when you're deciding that you want to move forward with the trademark application process, of course, we would do the assessment to make sure that you don't waste any money, but you also want to know the level of your trademark strength as well. So is it generic? Is it descriptive? Is it suggestive, or is it fanciful or arbitrary? After you've done a trademark eligibility assessment, then the next step is the comprehensive trademark search. This is the second step in the process. And the comprehensive trademark search means that you are doing a full search to make sure that your mark, your trademark, whether it be your business name, your logo, your slogan, your packaging, your colors, whatever it is that you're looking to register with the USPTO isn't currently in use. And that is what we would be doing for you. So we are searching the USPTO database for any mark that is identical to yours, that is phonetically similar to yours, orthographically similar to yours, to any mark that has prefixes, consonants, variables. We are searching, we are hunting, and we are looking for any marks that would be an issue for you getting registration with the USPTO trademark database. For instance, our trademark is Brand the LLC. So we're checking to see if anyone else is currently using Brand the LLC, but we're also checking to see if anyone else is using something similar to Brand the LLC, whether it's Trademark the LLC or LLC the brand. Anything along those lines, we want to make sure that someone else isn't using, because it can pose an issue for us down the line, which is an office action, which we will certainly get to. But we're not just searching the USPTO trademark database, we're also searching the internet, right? So we're searching website domain names, we're searching social media. Why? Because even though these website domain names or the social media handles may not be registered with the USPTO, if they are in business or if they are using their goods and services in commerce in connection with that website domain name or social media handle, then that can pose an issue for you because they have a common law trademark. And if you don't have a registered trademark with the USPTO, you also have a common law trademark. That is when you would see people using the TM symbol next to their business name or their logo or anything of that nature, which means that it isn't yet registered. It could be a pending registration, but it isn't yet registered. So that could pose an issue, and that is why we want to make sure that we conduct the search thoroughly the first time around. Which is why, even if you go on the USPTO website, they'll tell you that they recommend a trademark attorney in order to file your application because it is such a thorough process. So we are searching the trademark database, which we would use our own system. I know the USPTO has a free database, but we use our own system to make sure that the search is done right, because it is such an investment and we want to make sure that we aren't wasting your time or your money. You will receive an office action if there's anyone that currently has a registered trademark, anyone that has something similar, even if it's in a different language, because a trademark always has to be translated back to English. So for instance, Rouge. If your trademark name is Rouge, when you register it, you have to let the USPTO know that Rouge actually means red. So if there's anyone else in your industry that is currently using the term red to promote their goods and or services, then you would receive an office action for likelihood of confusion. That's what attorneys call it. It's a term of art, because the average consumer would be confused between your company, Rouge, and your competitor's company, Red, because the assumption is that the consumer is going to translate it back to English. So that's going to be an issue for you down the line. And then when you do receive an office action, you need litigation. But like I said, we're going to get to that in just a second. We're searching registered trademarks, but we're also searching what's called common law trademarks. And they can also challenge your trademark application, but we'll get to that in a second. So we're searching everything so we can know the strength of your trademark and prepare for any arguments that need to be made down the line. So with us, the next step is doing a memo. And in the memo, we would be telling you our analysis and determining the strength of your mark. Then after you've made the final determination as to whether you want to move forward with the trademark application, then we finally submit the trademark. Now, there are two types of applications you can submit. Generally, the first type of application is a 1A application, which means in use, which just simply means you are currently in business. You are currently using this business name to promote your goods and or services. You are currently using this logo. You're currently in business. And then there's a 1B application, meaning that you intend to be in business. It's called an intent to use application, and you have up to 2.5 years in order to use that application. You have to renew and let the USPTO know that you still intend on using this application every 6 months, but they give you up to 2.5 years in order to reserve that trademark before it's gone forever, and you have to start the trademark application process all over again. So you then need to determine whether you have an in-use application, a 1A application, or an intent to use, meaning that you haven't started your business yet, but you thought of this really awesome business name. You thought of this really awesome business logo that you've already created. You have to renew every 6 months just to let them know that, yes, I'm still working on it. I'm still working on my launch. However, they give you 2.5 years to preserve and protect your trademark, which goes to show you the importance of your trademark application. Once we've made that determination, which trademark application you would be using, whether it's a 1A or 1B application, we're also determining what classes you'll be using. What industry are you in? What industries are you in? We need to make sure that the fee is assessed properly, because the quote that we've given you is to cover one class. And each additional class is an additional fee because the USPTO charges an additional fee, and we want to make sure that the application is filed correctly and properly the first time. So we will determine whether you have 1A, an in-use application, or 1B, an intent-to-use application. And if you do have an intent-to-use application, we're going to come up with a timeline so we can know how long it's going to be before you actually launch your business, so you'll know how many times your application needs to be renewed, and you have to pay the fee to the USPTO to let them know, yes, I'm still using my application. But then we're also going to make sure that we have all of the correct classes. And frankly, we're going to make sure we have all of the correct classes when we do the search, because that is how we do the correct search. Because it's not enough to say that there's someone else using the exact same business name as you. There has to be someone else using the exact same business name as you in your industry or in your industries, unless that business is so popular, such as Google or McDonald's. That's the only exception. But that's the reason why we have Delta Airlines and Delta Dental. They have the same name. However, they're not in the same industry. The average consumer would not confuse the two. So we want to make sure we get those classes right to determine and identify the industry that you're in, the goods and or services that you're selling, And then we want to make sure we know which type of application you're using, whether it's a 1A application, you're already in business, or a 1B application. Once the application is submitted to the USPTO, it could take 3 to 4 months in order for it to be assigned to a trademark examining attorney, which is when the real fun begins. However, it could take longer. Obviously, that's out of our hands. That's up to the USPTO and the volume of trademark applications that they're processing and the other things that they have going on to determine whether it would actually be assigned to a trademark examining attorney. However, once it is assigned to the trademark examining attorney, the trademark examining attorney goes through the exact steps that we went through. So they are looking to see how strong your trademark is. Is it generic or is it fanciful and arbitrary? Then they're doing their own search on the USPTO database. They're also searching the websites. They're also searching social media because they want to see if there's anyone with a pending application, a registered application, or a common law trademark that you might be infringing on. And even if it's a pending application, your application will be suspended until that application is fully reviewed. And obviously, if that application is approved, then your application will be outright rejected, or you would get an office action. And if you can't overcome those office actions, then it would be outright rejected. So this is why it's so important to hire a professional to make sure it is done right the first time. And if the examining attorney does find that there's something wrong with the application, they would issue what's called, as I've previously mentioned, an office action. So they'll say, hey, there's something wrong with your application. You might be infringing on this person's application, or what you've submitted with your application isn't right. You've provided the wrong specimens or evidence showing that this is your trademark that you're using. There's something wrong with this application that needs to be resolved. However, once that is resolved and those office actions are overcome, then the application would move on to the publication phase, which means that it would go to the Trademark Gazette. So there are legal teams that are actively monitoring the Trademark Gazette, which is the USPTO's trademark newspaper, and they're actively monitoring this Trademark Gazette to make sure that their clients' trademark rights aren't being infringed upon. So this could be Google, this could be Microsoft, this could be Delta Airlines. You name it, there are legal teams actively watching this registry to make sure that their rights aren't being infringed upon. But on top of that, there are trademarks that aren't registered with the USPTO that also have access to the Trademark Gazette because it is public information, and they can file what's called a notice of opposition in addition to, of course, these registered trademarks. But even if you don't have a registered trademark, you can file what's called a notice of opposition stating that you don't want this to be registered because it's infringing on your rights, even if it is common law trademark rights and it isn't registered with the USPTO. That is the type of weight that a trademark is given. That's why it has to go through all of these steps. Once you get past the publication phase, then your application is finally allowed to be registered, or if you filed a 1B application, meaning that you intend to launch your business, you receive what's called a notice of allowance. So once you launch your business, you just let the USPTO know. Of course, it isn't free. They charge a fee for everything. But once you pay your fee and let the USPTO know that, yes, I'm currently using this trademark, I know I said I wasn't using it before, but I'm using it now, then your application will be moved forward to registration. So this is a very long process. If you receive a notice of opposition, your case would have to go to litigation in front of the Trademark Trials and Appeals Board, where there'll be legal arguments. There's legal arguments for everything with the USPTO. You need legal arguments to overcome office actions. You also need legal arguments to overcome your notice of opposition and for your trademark litigation, of course. However, once that's all done and it is a go-ahead to register your trademark is finally registered, then you can finally celebrate. And this process can take 8 to 12 months from the point that you submit your application to registration, sometimes longer, like I said, if you have an office action, or If there's some type of litigation, it can take longer, but the good thing is that your protection starts as soon as you submit your application. So if there's someone else that comes behind you, say for instance, our trademark is Brandon LLC. If someone comes behind us to submit the application for Brandon LLC, whether it's the day after, 2 days after, whatever it is, their application is going to be suspended until ours is fully reviewed. And if ours is fully reviewed and registered, they'll receive their 2D or likelihood of confusion office action stating that they're infringing upon us. And if they cannot overcome that, their application would be fully rejected and you have to start the process all over again and get an attorney. Probably should have got an attorney from the outset because they wouldn't be in that predicament to help them with the process. They don't have to get an attorney, but obviously it's definitely recommended. So congratulations to you for choosing Brandon LLC to trademark your brand. We cannot wait to help you protect your brand, and we'll see you soon. Thank you.